Okay, now we're going to go to the question. Here's the first one. I'm going to ask Pat Broderick this one. Pat, is there a claim under 1681I if the consumer disputes the credit information directly with the furnisher? Is there a claim under 1681I if the consumer disputes the credit information directly with the furnisher?
The answer to that is no. The FCRA envisions that credit reporting disputes will go through the reporting agencies first, and so they've required furnishers of information to set up their procedures such that they can field disputes from the consumer reporting agencies and not necessarily disputes directly from the consumers. And so it's actually counterintuitive that a creditor is reporting information about you and yet cannot be found liable under the FCRA for failing to investigate a dispute if they hear about the dispute directly from the consumer. The furnisher has to hear the dispute under 1681S from the consumer reporting agency.
Okay, Michael Herron, did you have anything you wanted to mention on that point?
No, I think Pat is exactly right.
Okay, so then, Michael, this question is for you. Does the FCRA treat attorney's fees as costs for purposes of cost shifting under FRCP 68?
Unfortunately, it does not. And the Rule 68 offer of judgment can be a really powerful tool in cases. And again, I mentioned earlier that attorney's fees are really one of the issues that makes these cases attractive to plaintiff's counsel, and also I think frustrating for defense counsel and frustrating for the court itself, because you can have a technical violation of the FCRA and have damages capped at $1,000, yet if it's litigated over a long period of time, you could have attorney's fees well in excess of $100,000. And the courts have upheld those attorney's fees awards, even giving a nominal amount. And in other consumer statutes, the use of a Rule 68 judgment is very powerful and can make plaintiff's counsel really take a look at the strength of their claim, because attorney's fees may become recoverable by the defendant. But unfortunately, under the FCRA, the FCRA does not treat attorney's fees as costs.
Patrick Broderick, anything to add to that, or we'll go to a fresh question for you?
Yeah. I would just put a little addendum to that. I agree with everything my colleague just said. The only thing I would point out is that sometimes you can make an offer of judgment and use it as proof later on that an attorney's fee application by, say, a recovering plaintiff's attorney is inflated. And you can say that an offer of judgment could have been accepted before the other side incurred all of those attorney's fees. And so, although I agree 100% that it's not considered a cost, attorney's fees are not a cost under Rule 68, they can be used to argue, again, it's not binding, but they can be used to argue that an attorney's fee award should be less than that which is requested because of a party's failure to accept a Rule 68 offer.
Thank you very much.